All right, let's get started. Good morning, everyone. This is CABI Zoom call workshop, COVID-19 legal aspects. I'm Paul Chambliss, Vice President of CABI, and we have a distinguished panel. I'm very excited about the attorneys who are going to be here today. They're attorney members of CABI, and they'll be presenting information on transactions they have been working on, issues they've been dealing with recently that have been impacted by the COVID-19 pandemic. Our panelists are Julian Isbicki, who is also a sustaining sponsor of CABI. Thank you, Julian. Trevor Crow, Brad Benson, and Ty McKinstry. Just to let you know, we're recording today's session. We'll be uploading it a little bit later today. It'll be available for everyone to view. I know there's some people that couldn't make it at 11 o'clock today, so they'll have a chance to look at the information later on today. Let's see, what else do we have? Oh, if you have any questions during the session, just click on the chat button, submit your questions there. We're going to probably have about 40 minutes of program and then 20 minutes of question and answer afterwards. So whatever your questions are, please submit. Ben Marley's already submitted a question. Thank you, Ben. And let's see, what else do we have here? I think that's it. Without further ado, I'd like the panelists to introduce themselves, starting with Julian, and we'll get the program going.
Sure. So I'm Julian Isbicki of Isbicki and Langer. I think I probably know most of the people. We're a law firm focused on handling transactions and have been involved with CABI for a very long time. I think I started working with CABI members in 1994, so we've been at this a while.
Trevor, if you'd like to.
I go next?
My turn?
Okay, Trevor, go ahead.
Okay, this is Trevor Crow with Crow Legal, and we're kind of a three-attorney boutique corporate law firm. Does a lot of business purchase and sales, private securities offerings, and things like that. I've been involved with CABI for a little while, was on board, just got off this last session, and yeah, looking forward to the presentation.
Brad?
Yeah, I'm Brad Benson, partner in Volant Law. We're a full-service business law firm, full service including both transactional and litigation, business litigation. Been an associate CABI member for probably 4 or 5 years now, and pleased to be here.
And Ty?
Yeah, Ty McKinstry. I work at Isbicki and Langer with Julian. I'm one of 4 attorneys there. I handle most of our commercial real estate matters. I'm a commercial real estate broker, and I have a background on the commercial side of brokerage as well. I also own a couple of commercial buildings, so you know, I'm able to address a lot of the landlord-tenant issues from multiple seats, which I think has been helpful.
All right, thank you, panelists. Julian and Trevor are going to start off with reps and warranties, both from the buyer and seller side. They've got a sample contract on the screen, so take it away, guys.
Thanks, Paul. So we're going to do a bit of a role play. So I'm going to be the buyer's lawyer, and Trevor's going to be the seller's lawyer, and we're just going to talk about a handful of provisions which have been affected by COVID-19. The first one, actually, Trevor, keep it where it is. I didn't give you a heads up on this before, but the first one is Section 4.1 is actually the closing. I mean, we're used to having a specific closing date in this contract. By the way, this contract relates to a landscaping company, and maybe we'll talk about that a little. But then we'll talk about other kinds of businesses as well. So we're used to, in the contract, specifying a closing date. And in this contract, it says May 31, which probably won't happen in this deal. But now everything's more flexible. Now we're not looking at set closing dates. When I'm representing buyers want to know, buyers don't want to close a business until they've seen that business operate for a period of time after shelter-in-place orders have been lifted. They want to see the business function the way it should normally function as best it can notwithstanding, we're in this world of coronavirus. So, so like in letters of intent, I'm talking about deals closing by the later of July 15 or 60 days after shelter-in-place orders are lifted, things like that. So in a contract like this, we didn't change it here, but I can envision a contract also not being so set on a particular date, but being either a particular date or a period of time after shelter-in-place orders are lifted, after businesses have opened. I mean, I'm dealing with I have some deals now regarding businesses that are currently closed. So, my buyers aren't going to close the business until it's open and there's a period of time where they can see it be open. Trevor, any thoughts on that from the seller side?
No, I mean, I think part of the comments that I'll have throughout this is that it's all, you got to look at these deals as a whole and what other provisions or what, what is known going into this and what has been priced into the deal as far as assumptions. And so, you got to kind of look at this as a whole and how the purchase price was, how you arrived at that purchase price and decide, where things shake out in the contract based on that, in my opinion. As far as the closing date, I think that makes sense. And if it makes sense that buyers are going to want to see a business operate for a little bit post a, this stay-at-home orders. And I think, from a seller's perspective, obviously we would just want to limit that period to as little amount of time as possible to make sure that we can close the deal. The one thing also that I note in this is that if you were to close in the midst of the current environment, you may have a remote closing as opposed to closing at the offices, which may be a provision you put in there.
Right. No, that's true. That's right. All right. So let's move to section 4.5.3. Oh, there we go. So these are the contingencies, the closing contingencies. And so we have a pretty typical, there's no material adverse change in the business or the assets on or prior to the closing date. And then we added, and there are no governmental orders in effect, including in regard to COVID-19, that have the effect of limiting the operating of the business or negatively affecting its profitability. So it's really the same issue we just talked about. As a buyer, we're gonna want to know that coronavirus hasn't negatively affected the business before we wanted to have an out, not be required to close if there's a lingering effect due to COVID-19. Trevor, any thoughts on that?
Yeah. So from a seller's perspective, in my mind, I would say, obviously, we're trying to limit as many contingencies or conditions to closing as possible. Again, a lot of these things come off reasonable given our current environment. Now, I would say we might want to try to negotiate something in here to say no new governmental orders. A lot of times these conditions to closings are meant to protect things that come up that are unknown, and if we have government orders that extend past the closing date currently, that may affect, for example, the way that you do business in any sort of business, whether it's just the number of people you can allow in your location or something like that. We may want to carve out something here to say no new orders, and would be one way. The other thing is this last piece, or negatively affecting its profitability. In my mind, that comes off as a little bit too vague from a seller's perspective, and we may want to try to clean that up. Exactly what does that mean? A lot of things could negatively affect profitability from a government order standpoint, and maybe it's something that doesn't directly relate to this business, but arguably allows the buyer to get out because they say it tangentially negatively affects profitability. I don't have any wording right now off the top of my head, but that just, if I see this and I'm representing a seller, I would look at that and think, well, how can we maybe get more specific on what that means there?
Yeah. Trevor, you made an interesting point a bit ago about, how the deal is priced and what is or isn't priced into the deal. And I could see us in a deal getting pretty specific about what financials need to look like. I mean, this deal, I think it's $495,000. I mean, sort of having the parties really get pretty granular to go, if the financials in the full month before closing look at least as good as X, then we can close. If they look worse than X, we can walk. I mean, I can envision some deals getting that granular.
Mm-hmm.
It wouldn't be the easiest thing. And I don't remember ever, to be honest, I don't ever remember doing that. But that's kind of the world we're in right now, where there's this level of uncertainty and buyers really are uncomfortable and they're moving slowly and they really want to see things, see what businesses are looking like. But I can envision that in a particular deal, getting that granular and that concrete about financials.
Mm-hmm.
Yeah,
and I think part of that is,
I can imagine it.
Part of that in my mind is that from a seller's perspective, what I'd be worried about is a buyer coming in with a lower purchase price based on the assumption that there's going to be lower revenue moving forward because of the current economy and thoughts of where the economy is going in the future, and then not making the document kind of take into account the fact that that's already been priced into it. So I wouldn't want there to be more provisions in here that hamstring the seller that say, from reps and warranty standpoint or conditions to closing standpoint, when the buyer is kind of coming into this knowing that, hey, the economy may be bad and revenue may be lower, and we've already priced that into the deal.
Yeah, no, I think that makes sense. I think that's a valid point. So then we're going to move to 5.1.16.5.
Did you want to address 5.
Hold on, stop it.
1.7.
Yeah, that's right. Go there first. Thanks. And so this is your typical compliance with laws provision. This one doesn't have a knowledge qualifier. And so it's just a broad-based compliance with laws provision. Seller and the business are in compliance with all laws, statutes, rules, regulations, codes, and ordinances of any governmental authority that apply to the business of the assets. And neither seller nor any principal has received any written or oral notice that seller or the business is not in compliance with any laws. So that includes COVID-19. It doesn't specify, but that would mean every law relating to COVID-19, which would be provisions about social distancing, anything else that relates to COVID-19 that's a legal issue would be baked into that. Governmental orders, state or local, county if there are county. So that's all baked in. And just something I'm worrying about, coincidentally, our former next door neighbor owns a landscaping company and takes care of our yard, and was talking to my wife. And he was mentioning the fact that in order to comply with social distancing, if he sends 2 people to a job, they're going to drive in separate vehicles. And, because otherwise vehicles aren't wide enough to comply with social distancing requirements. So, laws can be as specific as that. Just something to think about in every deal is, how are the current laws and regulations? How do they apply to that particular business? And is the business in compliance with them? It's going to vary from business to business and industry to industry. Trevor, any thoughts about any of that?
Yeah, from a seller standpoint, we typically want to soften this rep a little bit by saying in material compliance with all laws, or compliant in a way that it doesn't cause a material adverse effect to the company or something like that. Just because there's if you uncover any business, likely they're violating some rule, regulation, or code in some sense. And this may be handled in the indemnification section with a deductible or something like that. But if not, you want to, from a seller standpoint, try to make sure that there's no ticky-tack violation of this rep where your seller's gonna get hit with something. You want it to be, if they're actually violating a law and it's really causing material harm to the company, that makes sense. But just a small thing that's not really causing harm or anything like that to the company, then yeah, they're likely probably doing it. Everybody knows it. And so we don't want to have this stern or this rigid of a representation.
Sure. All right. Let's move on. 5.1.16.5. So this relates to employees. Yeah, so this is brand new. So this is a brand new rep, as if there already weren't enough reps in a contract. Sellers made commercially reasonable efforts to protect employees, independent contractors in the business from COVID-19. To the knowledge of seller and principal, no employee or independent contractor of seller has contracted COVID-19. So pretty important. I mean, a rep that didn't exist in the world before, 6 or 7 weeks ago, but suddenly now a super important issue, depending on the business, to make sure that these issues are just called out in the reps. Trevor?
Yeah, no, I think this one is new and would be new for sellers to think about, and kind of like all these reps, they just need to be true. If you're talking to a seller, you just want to make sure that they're true, and to the extent they're not, then you got to revise them or take them out or fix it. And so this is one of those ones where I'd say talk to a seller and say, hey, this is coming in the contract. This is just the new world we live in, and there's probably going to be a rep on something like this. So let's take a look at what you're doing now, and let's make this true somehow. What efforts are you taking? Have we looked through the orders? Have you taken reasonable steps in accordance with those guidelines? We might even want to try to modify this rep to say this is what we've done, or that we've been in material compliance with the guidelines, and that's considered reasonable efforts. But yeah, I think this is one that you would want to talk to sellers about and just make sure that they are taking the steps to make this representation true.
All right, 5.1.17. So this one relates to suppliers. So it seems so quaint back in January and February when we thought coronavirus was just a China problem. And we thought our concern was supply chain issues. We have a client who imports thermometers and things like that from China. And he was back then he was having trouble getting his thermometers out of China because the Chinese government was buying them all, and there were none left for him to export to the US. And we thought coronavirus was just a supply chain issue and not the issue that's obviously become. So I don't know that this is going to be relevant to, I kind of took this contract and then doctored it for purposes of this program and added COVID-19 wherever I could, just so Trevor and I could talk about it. So I don't actually think in a landscaping business we'd have a supply chain issue, but I don't know. I mean, maybe we could. But anyway, this one's really, whether the business being negatively affected by the ability to provide goods or services because of COVID-19. Maybe not so relevant in this business, maybe super relevant in other kinds of businesses, and you got to think about supply chain issues. Trevor?
Yeah, I think this one is, depending on the deal, could be applicable or could not be. But assuming that it is, then, you want to, again, make sure that this is true. It doesn't seem like an unreasonable request for a representation from a seller standpoint, but the couple of things that I would say to beware of here is it says, neither seller nor any principal has received any written or oral notice. Now, depending on what knowledge or what is known to the seller, or who is considered seller, is that top management, is it the rank and file employees there? It may require some inquiry with working with the principal to say, hey, let's talk to your rank and file employees and the other managers in here to see, have they heard anything, or has there been any emails about suppliers coming in, or suppliers going out of business or not able to meet the terms of their contracts. So that would be something to think about. I think the other thing here is, there may be an increased want from a buy side to be introduced to suppliers and other people involved in the business now, and they may have the ability to negotiate that, if leverage has changed a little bit here. And so, one concern sellers always have is announcing the deal before it's done. And so going out and introducing a purchaser to all the suppliers before a deal is closed, some sellers are really don't want to do that for a variety of reasons. Obviously that, for one, they don't want it to get spread around to employees, and two, if the deal doesn't close, they don't want to have to come back and explain what happened. And so this is one of those ones where you got to talk to your seller and think, how are we going to do this? How are we going to actually introduce the suppliers? Can we do that before closing, or are we willing to do that? And I think this one will be highly customized based on a deal by deal basis.
Yeah, that's true. 5119. So this is work in progress, which is totally relevant to a landscaping business. And so I added in, no WIP project is reasonably expected to be materially impacted by the COVID-19 pandemic, including because either it will be canceled due to the pandemic or the applicable costs of completing the project will increase due to the pandemic. So one thing is, are there going to be cancellations? I mean, if you're a buyer looking at doing due diligence and looking at a business, and you're buying it based on an expectation of a certain pipeline of work, you want to know that that pipeline is there. And so from a buyer's perspective, you're going to want to do a lot of due diligence on the jobs. If it's a business that has fewer jobs, but they're larger, you're going to want to look at all of them and make sure they're proceeding. So it's just, are they still in the pipeline? And then, are their costs increasing? The good news is this is an outdoor business. I think you could probably provide landscaping work and maintain social distancing, and in terms of the guys being in the backyard and doing the work, and I think. Yeah, we need to let it.
There's always a dog on a Zoom call.
Yeah, that's right. This is a legitimate coronavirus Zoom call. There is a barking dog. And anyway, yeah, so are the projects going on? I mean, is there still the WIP that you expect there to be, and have costs changed because of requirements relating to coronavirus or COVID-19? Trevor?
Yeah, so, if this came in, Julian would send this over. So say if I was representing the seller on this deal and Julian sent this over, I'd give him a call and I would say, Julian, look forward to working with you again on this deal. Hopefully it goes as smoothly as our last one. And, I think buyer has come in here with a COVID discount purchase price. And so we assumed we're buying this business with warts and all. And so we think that some of this, stuff is already priced into the purchase amount, and there could be projects that go down, and we don't know. We have no knowledge of that, but that could happen in the future. So that could be one response. The other response could be this is totally reasonable, given that we're still looking for. We're still representing that. We don't think there's going to be a change in the company's financial performance moving forward, because this, it's the COVID environment is not affecting them, or they think it's going to come back, or we're trying to get top dollar still for the on the sale. And so I think this one again is kind of depends on the situation, but it's not an unreasonable request to have this rep in here, I don't think. depending on what assumptions were going into the deal.
And you know, Trevor, we don't make any unreasonable requests. Yeah. 5/1/25. Oh, so yeah, so this is the generic adverse conditions one, a rep to the knowledge of seller and principal. So this one's has a knowledge qualifier. To the knowledge of seller and principal, there is no existing condition, state of facts, or circumstances that is reasonably likely to adversely affect the business or prevent purchaser from profitably carrying on a business. And then we have some carve outs to that, except in regard to generalized economic conditions and the impact of COVID-19 related governmental actions. So our first draft to Trevor, or to the seller, Trevor in this deal, is actually has limitations to the adverse conditions rep. So we're actually providing safeguards to Trevor and softening, even in our first draft. You know, if it weren't Trevor on the other side, maybe we would delete that. But given that we have a good lawyer on the other side, you know, we're going to put that in and acknowledge, because if not, he's just going to put it in anyway. But, you know, so we're softening it. We're acknowledging that there are some adverse, so there's two kinds of adverse conditions. There's specific ones that specifically relate to this business, and there's more generalized ones that affect every business. And, you know, generalized economic conditions, we're in the middle of an economic downturn in a major way. And we're in the middle of a pandemic. So we're just acknowledging that. So, you know, so we're not, when we're talking about adverse conditions, we're not talking about that. We're talking about other things that are just specific to this particular business. That aren't generalized like that. Trevor?
Yeah, I think that's right, and appreciate you adding that in on this first draft here. I think that would be, you know, this is a pretty typical provision to have the adverse condition. The new piece is this COVID part and carving that out, and I think that's important from a seller's perspective now, because if you just look at the status, you know, if the attorney working on this just pulled an old agreement pre-COVID and didn't have this in there, then, you know, it's certainly something from a seller side you'd want to have that carve out at the end.
Mm-hmm. And I think that's all we have, right, Trevor?
Okay.
That's all we have.
Yeah, I think that's it.
All right,
Yeah.
great. Thanks, Julian and Trevor. Brad's going to speak about force majeure and business interruption. So, Brad, if you'd like to take it away.
Yes, sir. Thank you. Good morning, CABI. Thank you, Julian and Trevor, for that walk through the weeds of a contract that you guys do every day, CABI. I want to focus on a specific provision that you would find in such a contract and in other contracts, that being the force majeure clause. I'll thank Paul in advance for making my slides for me. I think he's putting them up now. I have three force majeure. Are they up yet?
Yep.
All right.
Can we see those? Yeah.
Business interruption would be the last slide. So the first slide is a force majeure clause number 1. Second slide, force majeure clause number 2. Third slide, force majeure clause number 3. Fourth slide, business interruption, and I'll just discuss that without a slide. So the first clause I've put up here is from a lease that I was involved with. If we read it quickly, no party shall be liable for a delay in performance or failure to perform its obligations hereunder under this lease if such delay or failure is due to the acts of God or any other event beyond the control of the parties. Beyond the control of the parties, second control could come out. Now you can either put in examples, which many force majeure provisions do, or you can go with the more general language. I'll contend that you can, sometimes less is more. Sometimes you risk, you know, leaving out of the list something that doesn't happen, but it's not in the list and it's still outside the party's control. So I don't have a huge preference about that. I've done it either way, but it's pretty clear that if it's something, if we just argue about what's outside of my control, that would include government decisions, government restrictions. That would include hurricanes, forest fires, earthquakes, pandemics, I would argue. So, but I don't have a strong preference either way. I've seen it both ways. Provided, however, that the party is unable to perform, resume performance within, and then this is, a reasonable determination. Reasonable people sometimes disagree on what's a reasonable period, but that's a negotiable term. Usually, I don't always see people, or I seldom see people agree on what's a reasonable period. So you may have to negotiate that window. But that's a typical provision out of a lease that I actually did. Now let's go to slide 2. Thank you, Paul. This is also a lease from an actual lease contract. Wherever there is provided in this lease a time limitation for performance by the landlord of any obligation, including but not limited to obligations related to construction, repair, maintenance, or service, the time provided for such shall be extended for as long as and to the extent that the delay in compliance is due to the act of God or government control or other factor. Does anybody want to tell me the primary difference between clause 1 and clause 2? The material difference.
Well, the second one just relates to actions by the landlord.
That's right. The second one only excuses the landlord's obligations in the event of force majeure. And to be honest with you, most landlord forms start with that, from that position. Sometimes they say it a little differently, but they say the same thing when the clause can say all non-monetary obligations are suspended during the period of force majeure. Well, obviously, that means rent is not suspended. So an important thing to look for if you're representing a tenant, for sure. Frankly, this COVID-19 thing has greatly increased my force majeure practice, and primarily in the context of landlords and tenants, buyers and sellers. How's this all affecting my deal or my contract, my lease? And so force majeure is where we start. Everything under the sun is out there. There are contracts, leases, and others that don't have a force majeure clause. Probably not good lawyering at that point. I won't represent that I've never had a client sign a contract that doesn't have a force majeure clause in it. But now I'll be surprised if you ever see one going forward that doesn't have a force majeure clause in it, and a pretty broad one. And frankly, I think it will give tenants more leverage going forward. I've had landlords just tell my tenant clients, this is our lease. We're not changing it for you. If you don't like this, there's a building across the street. Well, I think you're going to see a lot more flexibility on that issue. Let me go to the third clause, Paul. Thanks again. So this is a force majeure clause that came out of an asset purchase agreement. And you can tell it's longer. It's longer because it's one of those clauses that I described that tries to lay out and identify all kinds of force majeure events. So just in case you're clear, we mean a lot of things. We don't mean a couple things. There's a lot of things listed. And to that extent, it's good. It covers probably everything I could think of, especially when you throw in at the end acts of God or acts, omissions, or delays in acting by a government authority. That would cover, quarantine instructions and social distancing requirements and masks and whatever is going on that the government's ordering to happen. And it's, as you can tell, mutual. So either side, if this was in an asset purchase agreement where it was, could use this provision to buy time, but it doesn't last forever. There's a 15-day notice requirement in this provision. You got to give 15 days notice that you intend to claim force majeure. And then this performance is only suspended for, it says at the end, shall be of no greater scope and no longer duration than is necessary, and the non-performing party shall use commercially reasonable efforts to remedy its inability to perform. So, we see these, a lot of contracts, almost every lease in some form or fashion, whether it's unilateral or mutual. I think you'll see them in every asset purchase agreement going forward. I think you'll see them have other clients with supply contracts, vendor contracts, service contracts. Those all have force majeures or will have them if they don't. The only suggestion I would make is, I don't know that I'd be more broad than specific. You can call out COVID-19, but if you only call out COVID-19, you might not, cover the next pandemic, whether it's COVID, 20, 21, 22. So sometimes, as I started, general or the more general is more helpful than the more specific. Just thoughts, but it's an important clause, and it's front and center right now for all kinds of obvious reasons. The second thing I'm going to talk about quickly, because I know I'm short on time, is business interruption.
Brad, before we move off that topic, any input on how people are dealing with legacy force majeure clauses or the lack of them?
You mean
we find
contracts they didn't negotiate? What do you mean?
Not contracts going forward, but contracts and leases from the past. A strategy for dealing with the fact that you don't have that clause in your agreements and you're facing the pandemic now.
Well, you're sort of at the mercy, I guess, of the goodwill and reasonableness of the other party if there isn't a clause. And in many cases, both sides are being impacted. It's pretty hard to get money out of a bankrupt client or blood out of a turnip. So I have landlords who are working with my tenant clients that don't have, either they have the unilateral provision or they have the non-monetary exceptions. I'm negotiating right now several leases that don't protect my clients. We're coming out with workout arrangements effectively that say we can pay you, we just have to pay you differently. And most reasonable people who want to get paid will listen to those things. I mean, an agreement is only what it says on paper. They're all revisable and amendable. And in the context of, if I don't work with you, I don't get paid. Get paid, that I'm working with anyhow, are willing to listen to a conversation to amend their contract. That's why I say I can't remember the last force majeure event, at least not a global force majeure event. I mean, there are hurricanes that affect the coasts, for example. There are earthquakes. Yeah, they don't usually affect an entire national or global economy. So there are plenty of contracts, if you assume them. I mean, that's every time you renew a lease, you get a chance to look at it again. But I don't know. I think you're at the mercy of whatever help the government can send you to survive it if you don't have force majeure to protect you, or you're at the mercy of goodwill of the other party to work with you because it's in their best interest to work with you. I haven't frankly had too many people say, tough luck, pay me. I mean, because this is of a scale that everybody's trying to work together that I'm working with.
Okay, thanks for that.
If you don't mind, one comment on that. I think that I'm not a litigator by any means, but what I've heard and what I've been reading about is I know certain people are there's court-created doctrines as well that deal with contracts. For example, the implied covenant of good faith and fair dealing is applied in all contracts in Colorado, regardless of whether that's in the contract or not. But there are other court-created doctrines like impracticability and frustration of purpose that I know certain people are arguing now to get out of contracts since there is in contracts that don't have force majeure clauses in it. And I don't know how successful people are at that, but it is certainly something that could be brought up from when you're trying to deal with the other side. I think Brad's comment of people are more willing to work with you, I think is true, and you should try that first. I guess that's kind of a backfall argument that you could make, or people could potentially make. I don't know how it would be held up in a court of law, but I know people are making that argument.
I think that's an excellent point. And to that point, you'd be better off having no force majeure provision, or maybe the parties didn't contemplate force majeure, than one that's unilaterally beneficial, because it was contemplated. And there's probably a clause in there that says the parties had a chance to review it, had a chance to have counsel look at it, et cetera, et cetera. So if it's been contemplated in black and white, it's going to be hard to say that it's bad faith not to, to not not impose it. I'm imposing an agreement that we negotiated. It's time, if you know, like I said, you could have gone across the street and got that clause, but you wanted to be here. So I don't think it's bad faith or fair dealing for a landlord to say that. But if there's nothing addressing it, it's not contemplated, you could argue pretty strongly that, you know, the implied covenant, which always exists, yes, suggests that you need to work with me, that you need to suspend my obligation. But I don't think it's bad faith for somebody to enforce the contract that was negotiated professionally. I can't say I've seen that question go up to a court yet, specifically as to COVID-19, and for sure I haven't. But I would not bet on the court to say, well, this is a bad outcome for this party, so we're going to reform the contract. I mean, like I said, right now, that good faith is that implied duty is being recognized, and in my experience, embraced by the other side. By the party that's trying to enforce a contract, they're saying, well, it doesn't do me any good to enforce a contract, put the person in bankruptcy and lose any hope of payment. It's just bad business. So, I mean, so far I've had everybody get on board with that, whether it's in the contract or not.
Okay, very good.
Quickly, business interruption. I don't know how familiar everybody is with this, but it's a coverage you can buy. I've seen it most in lease contracts where some larger landlords require tenants to buy business interruption amongst the insurance coverages they require under the lease. And obviously when tenants, in this case, or anybody's looking for relief, they're looking everywhere they can find, including their insurance coverage. This is a coverage they may or may not have. What is it? The general purpose of business interruption insurance is to make the party whole from damage caused by business interruption. And the point is you have to prove under the policy business interruption. You have to prove expense or loss for there to be coverage and for there to be to trigger coverage and payment for your loss. So you got two-pronged proof. But the bigger problem is, as with a lot of insurance, the devil's in the details, right? So not uncommon for someone to say, hey, I got coverage for business interruption, so my business has been interrupted by COVID-19 and I'd like to make a claim. Well, under pure business interruption coverage language, it may not be covered specifically. There are clauses within business interruption. There are coverages in addition to business interruption that are more on point. For example, a typical business interruption policy may exclude virus, bacteria, or disease, but you can get coverage for interruption by communicable disease, for example. That's a provision, that's a specific coverage you can buy by rider if you want to try to cover it. But even then, it may only cover certain diseases. It may exclude other diseases. So again, I think people are going to have a lot higher antenna on this. They're going to be looking at this a lot closer, the insurance sections of their leases specifically, to make sure that if something like this happens again, and I would suggest you should count on something like this happening again, people are going to be looking more closely at that coverage, and landlords are going to be probably requiring it at a higher level because they want, if you can't perform a source of payment in addition to you or your guarantor or whatever collateral you put up. So, and there's other specific issues. Does business interruption insurance cover government requirements to shut my doors? Many do cover that, but there's so many times it's also excluded. I mean, you really have to read the policy. This is another thing where, to pick up on your good faith, okay, an insurance contract in Colorado is bound by the same implied duties, but I think you'd have a hard time making a bad faith claim against an insurance company for not covering COVID-19 loss under business interruption insurance that specifically excluded virus or bacterial disease. So, you know, the best coverage, best protection, the best measures I would suggest are to use COVID-19 as a good case study for the kind of risks that heretofore have not been very realizable and very low percentage risks, but I think you'll see more of this. I don't I think contracts are going to now focus on these provisions. I think even 6 months from now, when we see the economic magnitude of what's happened with COVID-19, it's going to be more important. People are going to be protecting themselves in as many ways as they can from a recurrence of this kind of a response. And I think we should all expect this kind of response to become a little bit more than normal, especially if it proves to be effective. And I guess that's all still out in front of us. But anyway, the takeaways on the business insurance is that the language matters. It is a contract. The four corners of the document are going to have control first, so make sure four corners say what you want it to say. And then when you construe it, the court's going to look to not only whether you need to be made whole, but whether you get a windfall. And I'll close with an example. If a grocery store on Long Island ends up with business growing dramatically because people are leaving the city and going to the island, their business is way up for a month, and then there's a COVID outbreak in the store and they have to shut the store. Well, what's the measure of loss for that grocery store? Is it the measure in that month where they were rocking and rolling twice their normal sales because everybody was outside the city and on the island? Or is it their sales, more normalized sales over the years prior during the same period of time? Well, courts are not going to allow windfalls, okay, even if you have coverage. They may restore you to what you made last year, 2019, this time of year, but just because you crushed it in March, because everybody was out there, not in the city, they're not going to let you get a windfall under the policies. So I guess that makes sense. It makes sense to me. But yeah, I would advise, and I'm going to advise my clients to look at this kind of coverage. For one thing, you may not get stimulus money every time, so you may need this money. You may need this coverage. Probably worth making sure you have this kind of coverage, that you have the broadest coverage available, so that if it happens again and you don't have government help, you have contractual help.
Okay, Brad, thank you very much. Appreciate the information. Ty is going to give us some insight on landlord and tenant relationships during the pandemic. Things like rent relief, learning about your landlord, and what options you have as landlord and or tenant. Ty?
Yeah, I'm going to get into that. I'll kick off by hitting on a couple of tips and trends that I've been seeing in a couple of leases. I've negotiated about 7 or 8 leases since the pandemic began. And I've seen a couple of trends that I think are pretty telling in terms of what some tenants are able to get in this climate. Generally speaking, I've seen tenants have some additional leverage in today's climate. I think this is due to, landlords are sitting on vacant space, and a lot of those landlords don't really see an end in sight in terms of, when they're going to be tenants in the market again. So those tenants that are looking at deals right now are getting generally favorable terms. A couple of things that I've seen negotiated lately that are not usually big discussion points are, as Brad mentioned, force majeure. And to piggyback a little bit on what Brad mentioned, a tenant right now is pushing for mutuality. They're making sure that the force majeure clause applies to the pandemic. We've also seen some interesting language. I did sign a lease on a restaurant deal last week. And those guys were the tenant was obviously pretty concerned about the climate moving forward. And so we were able to negotiate the force majeure provision in a way that essentially read that, although the landlord was pretty stern on his position that the force majeure clause wasn't going to accept any monetary default, we came to an agreement on a position that essentially said that if the restaurant was forced to shut down by a governmental order, so stay-at-home order, say, or any other government regulation which prevented that restaurant from being open and operating sort of in the ordinary course of business, that tenant would get a rent deferral for the period of time that the business was closed. So if the business was shut down for 4 months, then starting 2 months later, they wouldn't have to pay rent for that 4-month period where they were shut down. And then starting 2 months later, they would go back to the normal rent that was due, plus an amortized amount of that deferred rent throughout the course of the lease. That was a situation in which I don't think that deal would have gotten done had it not been for that creative language. And I think I've seen a couple other deals where some form of that has worked. So I'd say that's one thing to sort of be aware of, is just sort of creative solutions to the force majeure issue. The other sort of trend that I've seen is I think landlords in today's climate are a little bit more willing to discuss default and remedies. I think usually a landlord says, if you don't like my default provision, then don't go into default. It won't be an issue. In the last couple of weeks, I've seen landlords a little bit more willing to come to the table and talk about things like personal guarantee. If they're going to insist on a personal guarantee, maybe they're going to go for a burn off or a cap on that guarantee. A landlord security interest is another thing that we've successfully negotiated out of a couple of these leases. And the last thing is some of these sort of more nuanced default and remedies provisions that landlords typically aren't willing to negotiate. In another lease that we've done recently, the inducement recapture provision, which essentially is a provision that says, any amount of the TI allowance, if the tenant goes into default, the portion of the unamortized allowance will have to be repaid by the tenant. And we've been able to successfully negotiate a couple of those provisions and essentially said that, we will pay back maybe the portion of the allowance that that was specific to us. That's going to benefit our specific space, but we're not going to repay the portion of that allowance that is maybe something that goes to the building that the next tenant would likely use. So say the HVAC or the subfloor or provisions or parts of the building that are more evergreen in nature. That's something that we've been able to get in 2 of these recent deals, which I think is sort of just telling again as to the general climate that I think tenants are able to get a little bit more out of landlords than they ordinarily would. So those are a couple of things to look out for in negotiating new deals. In terms of current sort of tenant issues, if you're dealing with a tenant or talking to a tenant that's facing default, one provision right now that I think is overlooked is the assignment and subleasing provision, because obviously there aren't a ton of tenants in the market, but we had a deal recently where the tenant was struggling, and it just so happened that there was a neighboring tenant, a manufacturing company that had tremendous upside and that felt really good coming out of the back end of this thing, and who had been looking for additional space for a while and said, you know what, even in these tough times, we're willing to take over our neighboring tenant's space right now because 1, it's a great deal, and 2, we think once everything sort of winds up here, we're not going to be able to get a space like this in the near sort of area. So although it's unlikely, I would advise your tenants and the people you're talking to at least get on the phone with their broker, their real estate brokers or you guys as the business brokers, and just tell that tenant, just do a little networking, find out, who knows, maybe there's a tenant in the market that has a need for this specific space or that, needs this specific build out. So I wouldn't entirely write that off. The other thing that I would advise, tenants to really look at is whether or not they have a personal guarantee. In this climate, I found that that's the single biggest piece of negotiating leverage. If there is a guarantee, a tenant's going to have a lot tougher time sort of working out some of these terms. If there's no guarantee, a tenant's looking at a landlord saying, look, my business is failing. We don't have many assets, and if you're not going to give me rent relief now, what are you going to get out of me in the future? Because there's really nothing left. So I found that the personal guarantee is sort of the biggest piece of this sort of puzzle right now. And so that's certainly an important thing to mention to any tenant. It's almost a first consideration if that tenant's looking for any type of rent relief is, what's the situation with the personal guarantee? I would say that, for those tenants that are sort of looking at staring down default and they're having a hard time right now, we've dealt with, dozens of these clients over the past couple of months. And, there are a couple common themes that I'd like to share with you on sort of what I'm telling those tenants and how we're sort of working through some of these issues. I think the first thing to sort of understand and to be aware of is, I think Brad had mentioned that most of these landlords are willing to come to the table and talk. I'd say those who aren't are generally constrained by specific things that make it more difficult for them. So for a tenant, it's important to know who your landlord is and know what their financial situation is. I think a mom and pop tenant right now is obviously in a very different situation than a big institutional tenant, landlord. A mom and pop landlord versus an institutional landlord are in very different places. I think that can affect the discussion in many ways. Also, the landlord's specific capital structure and the landlord's debt coverage ratios, those things are going to impact this decision. So, before just going to the landlord with specific demands, I would urge a tenant to do what they can to learn a little bit more. Because, I think an informed decision, an informed ask is going to be much more well received than something that's just sort of more off the cuff. The second thing I would mention to any tenant right now is to be proactive and to act quickly. I think a lot of tenants are in the same boat right now, and I would say the earlier a tenant acts in making a request for rent relief or opening up discussion with the landlord, the sooner that happens, the better. I think one consideration of this is I think a lot of landlords right now are going to be doing some additional due diligence on the tenant before granting any rent relief. So, if you go to the landlord 4 days before your rent's due and say, hey, I can't pay, the landlord's going to say, whoa, I need to see your financials. I need to look at your personal financials if there's a personal guarantee. I need to dig into this in a way that allows me to make an informed choice here. So definitely don't sort of put this off until the last minute if you're a tenant. Get ahead of this. Let the landlord know that, you've put some thought into this, and think about maybe going to that landlord with your financials, a P&L statement. Maybe you can make a compelling case that, here were my sales for the 12 months before this, and here are my sales projected for the 12 months after this, whenever it lifts. Make a compelling case. And I think it just helps to show sort of facts and to focus on things that both parties can understand. Next, in the conversation with the landlord, I would say that a tenant should know what they want and what they need. When we talk about the general term rent relief, there are a lot of different types of rent relief. The most common that we've seen is a rent deferral, which is essentially a temporary break on rent, but those amounts payable remain due just later in the term. So let's say you get 3 months of rent deferral. Those 3 months of rent are still due, but at a later time. And maybe those are due over the last year of the lease in monthly installments. Maybe they're amortized over the entire term of the lease. There are a whole bunch of different ways to structure it. Another ask is just for rent forgiveness, which means, what, landlord, I know I'm a couple of months behind. Why don't you forgive me for the rent that's already due and payable, and starting next month, I'll get back on schedule and pay you from here on out. Rent abatement would be, a temporary break on rent. So a rent abatement would be, for the next 3 months, I'm not going to pay, but starting month 4, I'll be back on schedule and pay all the rent for the rest of the term. There are also, different situations like a rent reduction where, for the next 12 months, I'll pay a little bit less and then get back to the scheduled payments after that. The bottom line is there are a whole lot of different ways to structure these this rent relief. And so I would think about, what the specific tenant needs and what they want, and to be creative in coming up with a solution that sort of works for both parties. The last thing I'll mention on this piece is that tenants should be prepared to offer something in return. Most of these landlords, all of these landlords, for the most part, have no obligation to even entertain these rent relief discussions. A lot of the times they're doing so, one, out of necessity, and two, because I think the relationship between the landlord and tenant is one that they're mutually dependent on one another for success. I think especially in today's market where there aren't a ton of replacement tenants out there. So I think it's important that a tenant comes to the table offering something in return. This could be anything from a new or additional personal guarantee, an increased security deposit, maybe an extension of the term. Maybe say, if you are willing to give me a rent deferral for 4 months, I'll sign an extra year on the end of this thing. That'll give the landlord some security that, coming out of this pandemic, that hopefully they'll have a tenant in place. Another thing that a tenant can offer is some additional financial documentation and disclosures. So, if you give me rent deferral, I'll give you a financial statement every month, both for my business and for me personally, if I have a guarantee, and that'll allow you as the landlord to sort of stay on top of the situation and not be subject to any surprises. The two last things that we've seen as sort of negotiating points here are landlord termination right, and this can be tricky, but we've seen this sort of worked in where you give me 5 months of rent deferral, and then starting in month 6, I'll provide you with my financials, and at any time you believe that my financials aren't suitable for you and you have another plan, you can terminate my lease. That's sort of an extreme position, but one that a tenant might want to consider in today's climate. And the last thing that a tenant could offer that we've seen is interest on the deferral amount. So not only is the rent deferred, but I'm going to pay you interest on the amount that's deferred. So in the end, the landlord ends up making a little bit more money than they otherwise would have. In summary, I would say in sort of this rent relief discussion that most landlords, as we said, have been willing to come to the table and negotiate. And I think it, again, comes down to the specific landlord. And we've dealt with one landlord recently that hasn't been willing to budge, hasn't been willing to provide any relief. And I think that's going to end up in a contentious litigation type scenario where neither of these parties is going to win. So, I think if cooler heads prevail and the tenant comes to the table being flexible and willing to offer something in return, I think, that gives both parties the chance for the best possible outcome.
Ty, thank you very much. I appreciate it. We've used up our hour, but we have had several questions come in. I was wondering if our panelists could hang in there for a little bit longer.
Yeah, I can.
Okay,
Yeah.
great. I know Trevor had a 12 o'clock call, so unfortunately he had to leave, but sounds like our other panelists will be able to stay. From Ben Marley, question about the promissory note. I know when Julian and Trevor were looking at the asset purchase agreement, we didn't really look at specific items like promissory notes, but is there any advice on having clawback provisions in promissory notes or forgivable promissory notes based on future performance, unknown future performance?
Sure, that's a great question. And I think we're going to see that. I think there's a lot of uncertainty now about how businesses are going to do. And I think we're going to start seeing deals that have promissory notes subject to reduction. So the price is going to be $1 million and the promissory note's going to be $250,000 of that million. And there's going to be an agreement among the parties that goes, if the business doesn't perform at a certain level, that $250,000 note may get reduced to some lower amount, maybe all the way to zero. Maybe the deal can range between $750,000 and $1 million, or between $1 million and not down to $750,000, but some portion of the way to $750,000. I think we're going to start seeing that. And one of the questions, I know we have a couple lenders on the call, at least I see Greg Bianchi right there, is I don't know whether today SBA rules allow us to have promissory notes subject to reduction. I know we typically can't go the other way. We can't have a deal with an earnout. And we can't say it's $1 million, but if the business performs really well, the purchase price will be more than $1 million. The way I understand the SBA rules is that we can't have a note, we can't have a deal with an earnout. But what I don't know today is whether we can have a deal with a promissory note subject to reduction, and whether that's kosher under the SBA rules. Maybe one of the lenders can sort of tell us that while we're on this call. But I think in answer to Ben's question, I think we are going to see those structures if they work, if our lenders will allow it. I think the way to bridge the gap, because of the uncertainty we now have, is to have notes subject to reduction. I think that's a really good point.
Greg, if you'd like to unmute and respond to that question, that would be great.
Sure. Can you hear me okay?
Yep.
Okay. Yes, that is something we're anticipating. We've looked at the SOP, and it doesn't state specifically that we can do that. That's one of the great lines that we'll be able to do. The earnouts, obviously, we can't, but we're anticipating our ability to accept those provisions.
I would only add that I would expect the loan documents to be the last to actually incorporate force majeure kind of relief for a borrower. I would more likely expect to see forbearance provisions maybe built in to a loan agreement, loan agreement, a promissory note that says, you know, we will forbear if there's a pandemic, but we will not necessarily suspend or somehow relieve. You know, the reason banks do forbearance agreements is because they want to make sure they protect all their rights. It's just we're not enforcing this, but we're not acknowledging default. We're not acknowledging relief. We're not acknowledging anything. We're forbearing from our rights. And I mean, I don't know how it's going to go because we're too early. But and SBA is only one realm of financing. If it's a small community bank, you'd probably be pretty successful negotiating a number of different directions. If it's a large securitized transaction, I wouldn't expect that you'll see that in there for quite a while. I mean, I could be wrong, but that's how I would predict it.
Thanks, Brad. Another question. Ben Marley and Lynn Abels want to know if we should, as brokers, have a hold harmless agreement for showings for buyer, seller, and broker. What opinion you guys might have on that? Okay, smiles, no answers.
Ty, do you know anything about that?
I'm sorry?
I was wondering if Ty might have some thoughts on that.
So protection for in-person showings, or if we need to have any disclosures about the facility, whether they've had illnesses or had to shut down because of illnesses or anything like that. Okay, well, I guess that'll be an open question.
Well, I think it's a hard one. I'll take a stab at it. I think you're better off. I mean, I'll put it in the context of my son's baseball coach called and asked the parents, do you think we should have practice and should we have a waiver? And I said, I mean, a waiver almost suggests a risk that may or may not be there. You're sort of identifying this as a high risk situation. I think I'd make it clear that you can see it or not see it. You can wear a mask or not wear a mask. You need to make an adult and informed decision whether you want to see it. If you're not comfortable seeing it without a mask, then wear a mask. If you want the parties on site to wear a mask, we'll ask them to wear a mask. But I don't know. I mean, first of all, waivers are not particularly effective. I mean, somebody's going to argue around the fact that, well, I didn't waive that your omission to take that action. I mean, that's gross negligence. I don't want to get into a fight about that. I would probably tell my clients to, do whatever makes you comfortable. But it's your decision. It's not mine. If you want to see it, I'll set it up. Okay. If you want to wear a mask and you want them to wear a mask and gloves, I'll set it up if I can set it up. But I personally would say we'll do whatever you're comfortable with. I'm not going to come out with a standard waiver. I wouldn't advise it right away. A standard waiver that says, you're going into a high risk situation. You understand that. And if you get sick, it's not my fault. Well, there's all kinds of things that may not be covered in that waiver sufficiently, and a good litigator is going to go right around or right through it, in my opinion.
Okay, thanks, Brad. One more question. This will be our last question from Lynn, and this is actually for Greg Bianchi. Is there any provision in the PPP docs that would preclude the seller from signing a contract to sell during the 8-week measurement period? And Greg, I don't know if you're still available. Yeah.
Yeah, I'm here. Read that one more time. Any provision within the PPP loan doc?
That would preclude the seller from signing a contract to sell during the measurement period. Which
no.
Measuring. Yeah.
No, and I've reviewed our docs, at least what we put into place with our Laser Pro promissory notes, and no, there are not.
Okay.
I have a question. I have a question about that because isn't the issue forgiveness? I mean, if you're a seller with a PPP loan and you sell the business before the end of the 8-week period, aren't you going to run into a problem in terms of maybe not getting the forgiveness that you would otherwise want?
That's right. And we're looking at the rules right now, and we're anticipating about 3/4 of our PPP customers having a balance at the end of the covered period of 8 weeks. So for majority of our loans, there will be a portion of, 2-year amortized debt associated with each one of these projects. That still won't preclude the sale.
All right. Thanks, Greg.
I guess.
Oh, go ahead.
Yeah, I just want to take another run at that because this is a real question we're trying to figure out right now. So if the seller, I don't know, let's just use simple numbers. The seller borrowed $100,000 and $75,000 of it would be forgiven. And if the seller sells the business before the 8-week period, are they going to lose the ability to have that $75,000 be forgiven? In other words, do they need to wait beyond the 8-week period or even beyond the end of June to sell the business just to make sure they get the full benefit of the forgiveness on the part of the loan that can be forgiven? Because that's a question we're trying to deal with a number of deals right now.
Yeah, I see where you're going. And at this point, we don't anticipate that from tricking up our clients. I'm working with 2 right now that have PPP loans in place. And even if these sellers don't get around to getting full forgiveness, what's more likely to happen at that point of sale is whatever is sitting in their PPP checking account would be dispersed back to and pay off the loan.
All right. Thanks, Greg. And that's going to wrap up our session today. As we're winding down here, I wanted to just put up the information for our panelists today and thank them very much for being a part of this. Julian, Trevor, Brad, and Ty. I would also like to remind our viewers that the IBBA online conference is taking place. It started this week on Monday. It'll be taking place through the month of May, all the way through May 31st. If you have some interest in signing up for it, you can go to ibbaconference.com. I think it's $200 for IBBA members, $300 for non-members, and they have multiple workshops each day of the week through the end of the month. So good opportunity to find out what the experts have to say and build up your practice. I think the big takeaway from today's workshop is that we all are in the business of creating win-win situations for our clients and our customers, and people are changing their expectations based on the environment that we find ourselves in today. That's all I have for today. I appreciate our panelists joining us, and thank you all for attending, and that will conclude our workshop. Thank you, and goodbye.
Thanks, Paul.